Judgment in the long-running Avid corruption and theft case involving $30 million from the Social Security Commission was delivered in the Windhoek High Court a short while ago. Joining us live in the studio is legal analyst Yarukeekuro Ndorokaze. Good afternoon, Mr. Ndorokaze, and thank you so much for joining us.
Yes, good afternoon. It's good being here.
Please give us a background of this high-profile case that has technically been running for years now.
All right. This matter has its origin in around 2005 when about $30 million of investment was paid by the Social Security Commission into the Avid Investments Bank account. And from there, money was then transferred into the Namankol account. And from there, it appears to have disappeared. And that's where subsequent to what, there was an inquiry. Now, this inquiry's objective was to see whether there was any fraudulent activities within the running of this company and whether there was intention on the behalf of the directors to defraud the investors, in this case being the Social Security Commission. That's where the roots of this matter is, and it has been ongoing for a while. And now, around 2008 or so, the directors were then charged, and this case has then been going on. As they say, the wheels of justice turn at times very slow, but they turn all the same.
Now, what was the official ruling handed down by Judge Christy Liebenberg?
All right. The accused persons are 7,
okay,
of whom 4 of them are directors of the companies. Others were just people acting and seemingly going on with promoting the ideas of the Avid investment. Now, when you look at some of the directors, like for instance, if you take the first accused in the matter was Paul Escapia, he was convicted of fraud because it was found that he lied to the Social Security about the involvement of Mr. Kandara, the late Mr. Kandara, within the Avid operations, because that's one important factor that Social Security wanted to find, and they sought assurance that he was not involved. But it appears from the evidence produced before court that he lied about that. Also, the chairperson of the Avid board at the time, Ines Casas, was also convicted of fraud because there was no evidence that as directors there is an obligation that they have, because directors are acting in trust on behalf of the shareholders of the company. So if there are any operations within the company that is going on, they are supposed to inquire, they're supposed to interrogate, but it appears they did not have that, and they allowed Mr. Kandara to run the show. Therefore, the court then found that she might have acted in consent or in cahoots with that, or laid, whatever they did, laid the ground for Mr. Kandara to do the things that he is alleged and has been proven to have done. Now, the third accused was Mr. O'Neill Potofitz, who was also a director at the time, but he had resigned from the board of Avid around 2004. So when all these things happened, he was already no longer involved in that, and hence he was also acquitted of that because there wasn't much connecting him to that. Another director of the company was Sharon Blau, and she was acquitted of fraud, but she was found guilty of contraventions of Section 424 of the Companies Act. That's the old Companies Act that has been repealed. But the same provisions of the old Act and the new are similar, and as a result, she was convicted of that because it was found that she also contributed somehow to the fraudulent conduct as read in terms of the Act. Now, the fifth person was then Ralph Blau, who was also convicted of fraud, and his particular role that stood out was that he's the person who submitted the company's profile to the Social Security Commission, which basis the company profile was the main document that the Social Security then considered in seeing whether they should invest with Avid Investment or not. For that role, because although he was not a director of the company, but for that active role that he played in this regard, he was then convicted of fraud. Then the sixth accused here was a retired Brigadier General, Matthias Shiweda. He was rather acquitted of all the charges that he was facing because at the time, he had indicated that he did not want to become a director. His interest was rather to get some shareholding within the company. But then when he also saw that certain things were not happening the way he would have expected to happen, he also questioned some of that. So his was more a passive role, hence they could not link him to that. And then the seventh accused was Mr. Nico Josia, who was convicted of theft because of the role that he played. He was also convicted of the contravention of the Companies Act, that's Section 424 of the Companies Act. Now, the court found that between Mr. Josia, the late Kandara, and a certain Alan Rosenberg, South African-based, between the three of them, they must have worked in cahoots, and their intention was deliberate, and they were intent to defraud the Social Security Commission of this investment. And as a result, he was then found guilty of theft. Because his argument, Josia, that is, was that he actually just took a loan from Mr. Kandara. He didn't know where the money came from. But from the evidence provided and produced before the court did not hesitate in finding that he knew it was Social Security's money, and he also knew that they had already planned that they were going to defraud the Social Security of this money.
All right. So now for the 5 that have been found guilty, what happens now?
Now that's a tricky one because all 7 of them are out on bail. The 2 of them, Mr. Potovits and Mr. Shiweda, would be going home after all this. Now, they were on bail because they were accused. They are no longer accused. They are now convicts. And therefore, there are new other considerations that the court would then have to consider. Because the most important thing is that now that they know that they have been convicted, would they still be around to now face the punishment that awaits them? Or would they be tempted to escape, to abscond and not stand trial? And that's the factors that the court would now have to apply its mind to. When I left the courtroom, they were still busy with aggravation and mitigation, which is the process where the accused would then say why the court needs to be lenient with them, whereas the prosecution would also advance arguments to say the court must actually produce the harshest sentences as possible. Now, fraud is a common law crime, and in most cases, because it has an element of misrepresentation, where somebody would have been in a position of trust, but then they would have betrayed that trust there and have misrepresented themselves. Normally, courts would prescribe a custodial sentence. So too for theft. Now, the violation with regards to the Companies Act, the section 424, there is a fine prescribed there, and coupled with that is also a possibility of a prison term. So the court there would have discretion as to whether they would fine them or they would give them custodial sentence. But that's the discretion that the court would deal with. All I can say is that some of them are likely to be getting custodial sentences. Others could be fined. Others could be suspended sentences. It could be sentences but suspended all the same. But that's the discretion of the court to pronounce itself.
Once we actually get to the stage of
yes, once the aggravation and mitigation is done, I'm not sure whether the judge would proceed in handing down punishment today, or we'd set another separate date for sentencing and apply his mind to the factors that the accused persons would submit, which would range between things like first accused, they were not necessarily reckless, they were probably just negligent, that they didn't ask, they didn't inquire more, they did not intend, they did not have the intent, and all these other things. They would then consider those factors and see what is the appropriate sentence. But what is clear is that, and that's the point that the judge also made, was that what has gone missing is taxpayers' money, and therefore society is very much interested, and society would also want to see that the court plays its role, and there is no confidence that would be lost in the court and the judiciary system. So they would have to come to play in deciding as to what is the appropriate sentence in this particular matter.
Excellent. And on the part of the money, of course, that...
Well, the money has actually, what happened is that when it was transferred into the Namagol account, it was then transferred onwards into a South African account. Okay. But through some processes there, about 14.5 million or so was then re-transferred back into the Namagol account. But what is clear there is that when the money came into an account, it actually came into an account that was personally held by Mr. Nico Josia. And from there, as the court has put it, he went on a shopping spree, donating money to welfare, charity organizations, families, church, buying cars, and all these other things. So the 14.5 that was received from South Africa was actually spent. However, with the liquidation of Namangol and Avid investment, about 10 million was recovered. And the belief is that that would have then been transferred over to the Social Security. However, the loss that the Social Security would have incurred in total would be around 20 million or so.
Of the total that obviously has gone missing. Mr. Ndorokaze, thank you so much for your insight, and we definitely look forward to having you again soon.
Always a pleasure, and I'm looking forward as to what the sentences would be.
Absolutely. All right, well, there you have it. That was legal analyst Yarukeekuro Ndorokaze talking to us about the judgment in the case of the Avid corruption and theft trial involving $30 million from the Social Security Commission that went missing.